Bhavya Gujral, may I request you to kindly felicitate Madam Rema Rajeshwari. May I request Mrityunjaya Roy to kindly felicitate Narasimha Reddy Garu. Mrityunjaya Roy. Thank you, sir. May I call all of you for a good picture? So may I request you to stand for a group picture? Thank you, sir. We start with the next session right away.
Former DGPs in the country to please join us on dais. One of our most distinguished police officers who handled some very, very difficult insurgency situations for our country. To us, it is an absolute honor to have you chair this session. As the two speakers, let me first call upon Professor Balram Chauhan, former Vice Chancellor of National University, Bhopal, National University, Lucknow, and the founding Vice Chancellor of Dharmashastra National University, Jabalpur, currently working as a state lead in Uttar Pradesh in a think tank called this. Sir, please join us on that. And next, may I invite Shri Vikramjit Banerjee, Additional Solicitor General of the Government of India, and the Advocate General, former Advocate General of the Government of Nagaland, to please join us on dais. Before I hand over the session to Shri K. Kumarji to kickstart the discussion and guide the conversation with our speakers, let me just say what a deep privilege it is and a matter of personal pride for me to be inviting two speakers with whom I have a personal connection. I was a student of Professor Balram Chauhan, and Vikramjit Dada has been a mentor to me since the start of my career. So, thank you. With those words, may I request Rajan sir to please take over the proceedings. Thank you.
Heavy morning schedule, 3 hours of physical activity on the course. Most of us used to snore off in the classroom, and the law used to be with books, open books. So if we managed to get through. Now, having said that, I'm extremely grateful to India Foundation for extending me this invitation to chair this session. Initially, when I was asked to chair this session, I said I'm least qualified to speak about BNS, a new law, the new 3 criminal laws that have been passed by the Indian Parliament, while I belong to the old school, I'm a creation of 19th century. As I talk to you, I'm a creation of 19th century policeman, 1861 Police Act. I also implemented the same 19th century law, tried to provide a world-class service to the 21st century Indian citizens with the 19th century tools. That's what I am at the moment. So when I was asked to chair, I was very reluctant. Then I was told, no, you don't have to speak anything. You just have to listen. That's what my learned friend, Mr. Ramchandra Rao, told me, for which I agreed. Having heard everyone here, being the last one to chair, I am practically left with nothing except to repeat what all has been said. However, I did prepare myself to speak a few words on the topic I did go through. Having a separate constitution, a separate flag, and separate criminal laws. I learned the IPC, I learned the Criminal Procedure Code of India, and I learned the Indian Evidence Act. And to my horror, I was allotted to the J&K cadre, where I had to operate under a different constitution. J&K had a different constitution prior to revocation of Article 370. So we had a different constitution. Instead of IPC, we had the Ranbir Penal Code, we had the Criminal Procedure Code, and we had the Evidence Act of Jammu and Kashmir. However, mercifully, most of the sections are corresponding. Now you have a system wherein a new law, the colonial laws have been repealed. Our own laws, which are transformative and progressive in nature, have been introduced and have been notified, which will be coming into force from 1st July 2024. It came very suddenly. It has caught the legal practitioners and everyone mostly by surprise, because we were not really prepared, though we were pushing for it. We were pushing for the reforms in the criminal justice. And these things the criminal justice reforms cannot happen in a vacuum. It has to be, simultaneously done in conjunction with the police reforms, the ones who need to implement them on the ground. My earlier colleague spoke about the difficulties in the forensics. Are we ready? Do the states, police and public order being a state subject, do the states have the structure that is required in terms of the forensics, in terms of the collected between various states? Though the government of India funds heavily under the modernization of police forces, but yet the states need to pump in additional resources for having these systems in place, be it the prosecution, be it the training, and finally the will on the part of the police forces, the mindset they have been used to. Like I said, I belong to the 19th century. For me to catapult into the 21st century, I need as a policeman the motivation, the will to get into that. Now, with this, I would not like to waste much of the time. I would like to say, but while we talk about the offenses against the state, in the old laws, in the IPC, it was under chapter about, especially it talks about sedition. Whereas in the new laws, it comes under chapter 7. So in the old laws, it is from 121 to 130, and in the new laws, chapter 7, it covers from 147 to 150.
At the outset, I would like to thank India Foundation as well as the Vice Chancellor of NALSAR, Professor K.D. Rao, for providing me this wonderful opportunity to be the part of this conference. Believe me, it is one step which will bring several good things in future. Why I am saying so? The legal framework in India is on the brink of substantial transformation with the impending implementation of the new criminal laws. We are discussing BharatiyaNyaya, and there were discussions about Nyaya. You see, justice is a philosophical term. Honorable judges who are sitting here, learned advocates who are sitting here, every day you are fighting for the cause of justice. But this justice is not that justice about which we are talking in the Constitution. When we talk about the justice in law, then we need to say that it is the duty to find out the best element of law. It is duty to find out what is just in law as well as in equity. And according to me, this is the first requirement for the proper implementation of BharatiyaNyaya Sanhita if you really want to make this Sanhita successful in future. Second, I don't know. Yesterday evening, when I was just thinking, I was received by one Yashwardhan, Mr. Yashwardhan, intern. Thank you, Yashwardhan, for doing all good things for me. And I wanted to ask that question, but I will ask in the last. But the discussion which I had with him, it reminded me, First Law Commission, there were 3 members, Macaulay, Millett, MacLeod. 3 M's, M, Q. They drafted the Indian Penal Code from 1834 to 1838. Then, of course, Peacock revised it, and then it was enacted from 1st January 1862. But again, another M has introduced the new BharatiyaNyaya Sanhita. Don't you think there is a role of this M alphabet more as far as the criminal justice administration in our country is concerned? It is on the lighter side. Think about that. Millett, Macaulay, Millett, MacLeod. What I am trying to say, when I reviewed this BNS, I found that now it is having 356 sections against the 511 which it was consisting previously. A meticulous review revealed that in this Sanhita, 175 sections have been changed. They are the same, but some changes have been made in those sections. Has been incorporation of 8 new sections, only 8 new sections. And the deletion of the 22 sections. Friends, remember, this code was drafted in pre-colonial era because the power was transferred to the government after 1857 Great Mutiny. Before that it was pre-colonial era, but it was enacted in the colonial era. And the topic which I am going to discuss is offences against state. Initially, when the code was enacted, there were 10 sections from 121 to 130.
A very, very illustrative and educative speech. He has spoken extremely well about the number of, the sections that have been clubbed together, brought down from 511, that has been brought down to 356, the four principles of, the entire seditions. Then he has spoken about substantial transformation. And then a very interesting thing, the criminal law is a source to eliminate the Ravanas in the society. And of course the sedition law which was upheld in 1962. Now before I offer the mic to the next speaker, Mr. Vikramjit Banerjee, Honorable Additional Solicitor General of India, I have a doubt because I am also a learner now. With the Supreme Court placing a bar on registration of cases under 124A and the new act which is just notified and had to come into play from 1st July. So what happens to such acts committed now? Can I do any act which endangers the unity, integrity and sovereignty of India between now and July 1st? Can I get away with that? Now this question I am throwing to the next speaker, Mr. Vikramjit Banerjee. The mic is yours now.
When I was asked to speak on this topic, and especially on the crimes against the state, my take on that is this: that we have the IPC, we know the provision of the IPC, 124A, and I'll go through the history of why that came into being. But most finally, how the act is worked out will be worked out by the courts. So it will be worked out by you, by the public prosecutors all across the country. So that's a separate issue. But what is the difference in approach in this conception of sedition, and how should we look at the new provision? My suggestion to you is that there is or has been a jurisprudence on sedition under the IPC 124A because of its history. And that history, as we'll go along, is intricately linked to the colonial struggle. So whenever we look at that provision, we look at it in two ways. We look at it as a colonial imposition. That's one, because that was the clear intention. There was no doubt about it. But we also look at it in context of the number of freedom fighters who were arrested under those provisions. So our mentality of how the jurisprudence of these provisions are shaped actually by our experience of that provision. Now, of course, number of judgments and number of things saying that you dilute the provision and you don't look into it and you look at it afresh. Fine. But what I think is when we need to look at the new provision under the Nyaya Sanhita or the BNS, we need to look at it with the mental approach that you are looking at it. How would the new India look at it? And the new India faces some of the problems which the British did, the colonial state did. Maybe exaggerated maybe even more in context of, the internet, in context of the means of communication, in context of various different things. I think I to a certain extent disagree with Justice Lalit when he said that maybe it's better that terrorism existed outside. I think it's a good thing it's part of the BNS or the penal code, whichever generally speak about. I think it's good that it's been incorporated because a consolidation of criminal statutes is extremely important. That being said, I'll come put that in context and then come to what my major talk or whatever this small thing is about. The changes of sedition, which Justice Chauhan spoke about, and subsequently it was changed again once in 1898, what came in 1860. It came after the First War of Independence in 1857. The approach in 1860 was specifically made because this was, I think, the first provision when the British state realized that the old powers whom it had worked against in 1857 were dead. The princes were gone. The old world of feudalism, in many ways which they were used to, was dying, had no future. So it had to actually now address the next question about people's objections against the government. So it was brought up in that context. Very many people say it was brought up in different contexts. And some say because there was an outpouring after 1857, people were then slowly coalescing.
When came Munshi, and also about Shyam Prasad Mukherjee, I feel a little connected to Shyam Prasad Mukherjee, attempted to talk a little about him. In fact, he is the one responsible for what has happened in J&K today, resulting in its total integration with the country. He was the one, as a minister in Nehru's cabinet at that point of time, led the Praja Parishad agitation and went to the state of Jammu and Kashmir. At that point of time, J&K had a prime minister and a permit system. One could not enter into the state of Jammu and Kashmir till 1964. So in 1953, he went to the state. At the border, he was arrested and incarcerated in the jail under the same laws. And he dies in the Srinagar Central Jail. Subsequently, this picked up. He was the one who was given a call, Ek Desh mein do pradhan, do vidhan, do nishan. Means, in one country there cannot be two prime ministers, two constitutions and two symbols cannot exist. So that has subsequently caught, and this system has been abolished in 1964, and then they started the prime minister, from prime minister they switched over to the governor, and to the chief minister, that designations have been started. But he has laid the foundation for integration of the state with the rest of the country, and it was realized on 5th August 2019. So that is where I thought I was tempted to talk about him. Now the challenges, a few challenges which we are going to face with. Well, it is Rajdroh versus Deshdroh. Rajdroh under sedition is accepted. You can say anything against the government as long as it doesn't result in the other things, treason. But Deshdroh, treason, is not accepted. Secondly, for the practitioners, be it the police, be it the advocates or the judges, we need to first reorient ourselves to the new laws. Then unlearn the old and relearn. So reorient, unlearn and relearn. Then we also know all these laws are prospective in nature. So what happens to the cases? There are a large number of cases on which there is at the moment there is a stop. The cases are under trial. They continue to be tried under the past laws, old laws. And the new laws under the new sections under 152 of the BNS, which are very, very elaborate. So what happens to that? Some of the laws are extremely progressive in nature, like trying proclaimed offenders in absentia. Today you can only attach their property, but you cannot try them in absentia and then convict them. Now it's very, very progressive. Similarly, time-bound investigation, you cannot keep on dragging on forever and ever and ever and ever. The number of adjournments have been brought down. Time period for investigation has also been laid, even for judgments. and acceptability of electronic and digital evidence, forensics, so on and so forth. All said and done, the BNS is a really, as Mr. Banerjee has said, a transformative act, but the challenges will continue. Earlier, we had 100 or 1,000 odd laws in all the three laws put together, the IPC, the CRPC and the Evidence Act put together, it was 1,000 odd. Now, we have another 1,000 odd laws in the new BNS. All put together, there are going to be 2,000 laws with which we need to grapple with. So, ladies and gentlemen, I rest my case here and my lecture. It is for the youngsters here. I find a lot of youngsters. You have a huge task in your hands. Whatever you have learned till date, now you need to further reorient yourself. I am also extremely grateful to India Foundation for giving me this opportunity to chair this particular very important session which is going to affect the future of our country, taking it forward into the 21st century, not just take it forward. We are looking at being a 5 trillion economy. We are looking at becoming number 4th economy in the next 5 years. With this, I think the session is to be concluded. I hand over the mic to my, yes, what's your name? Well, to you. Thank you so much.
Request the dignitaries of the dais to be felicitated. First, starting with the chair for the session. Next, may I request Abhish to present a token of appreciation to Vikramjit Banerjee, Additional Solicitor General of the Government of India. And finally, may I request Mr. Manav Kumar to present a token of appreciation to Professor Balram Chauhan. Taxman Publications, on behalf of the organizers, has got copies of the BharatiyaNyaya Sanhita for the speakers on the dais. May I request Abhishek and Vijay from Taxman Publications to present a copy of the BharatiyaNyaya Sanhita to the speakers.
Thank you so much. Compliment to someone else. Thank you so much. Have a day. So this one is a major except that is a major.
Thank you. With that, may I invite my colleague Hafsa to present the vote of thanks for the evening.
It's a very timely and thoughtful conference, and thank you all for being here. I thank our Chief Justice, I thank our Chief Guest this afternoon, Justice UU Lalit, and all our esteemed speakers today. A special thanks to Justice J. Madhavi Garu, Honorable Judge of the Telangana High Court, for taking time and sitting through this entire conference. Thank you, retired judges, Vijay Lakshmi Garu, Seshasena Reddy Garu, Praveen Kumar Garu, for taking the time out and being with us today. I thank my senior colleagues at the bar, senior counsels, public prosecutors, government leaders, my dear brothers and sisters, law students and ladies and gentlemen for the time and patience and your presence at this conference. I thank NALSAR University, Professor Sri Krishna Devarao Garu, Shanti ma'am, and your entire team for putting this together and being with us. Partners, Taj Deccan and its staff for your warm hospitality. And Ramchandra Rao Garu, Avnish, Madhukar, and Manav, and his entire team, without which this event would not have been possible. I also thank, last but not the least, my colleagues from India Foundation, Apur and Yani, to make this event a grand success. Thank you all in the hall next door. Seeing you all in more.